Hello. Today I'm going to read from For the Record, Documentary History of America, edited by David Shee and Holly Mayer. And this reading is Plessy Ferguson, a case from 1896, the Supreme Court. Augustus Straker alluded to the growing social separation of the races in the South during the 1880s. Practices varied from county to county, state to state, but by the 1890s the trend was clear. White Southerners were determined to mandate a racially segregated society. The Louisiana Ordinance of 1890 required that railroads provide equal but separate accommodations for white and colored races. A group of New Orleans blacks resolved to test the constitutionality of the law. One of them, Homer Plessy, sat in the whites-only section of a rail car in 1892 and was arrested. 4 years later, the United States Supreme Court heard his case when Plessy appealed a ruling by District Judge John H. Ferguson. 7 judges upheld Plessy's conviction, and only one, Justice John Marshall Harlan, son of a slaveholder from Kentucky, dissented. Harlan put forth a powerful defense of equal rights. Justice Henry Brown for the majority. This case turns upon the constitutionality of an act of the General Assembly of the State of Louisiana, passed in 1890, providing for separate railway carriages for white and colored races. The constitutionality of this act is attacked upon the ground that it conflicts both with the 13th Amendment of the Constitution abolishing slavery, and the 14th Amendment, which prohibits certain restrictive legislation on the part of the states. 1. That it does not conflict with the 13th Amendment, which abolished slavery and involuntary servitude, except as a punishment for crime, is too clear for argument. Indeed, we do not understand that the 13th Amendment is strenuously relied upon by the plaintiff. The object of the 14th Amendment was undoubtedly to enforce the absolute equality of the two races before the law, but in the nature of things it could not have been intended to abolish distinctions based on color, or to enforce social, as distinguished from political, equality, or a commingling of the two races upon terms unsatisfactory to either. Laws permitting and even requiring their separation in places where they are liable to be brought into contact do not necessarily imply the inferiority of either race to the other, and have been generally, if not universally, recognized as within the competency of the state legislatures in their exercise of their political power, police power. We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it. The argument also assumes that social prejudice may be overcome by legislation, and that equal rights cannot be secured to the Negro except by an enforced commingling of the two races. We cannot accept this proposition. If the two races are to meet on terms of social equality, it must be the result of natural affinities, a mutual appreciation of each other's merits, and a voluntary consent of individuals. Legislation is powerless to eradicate racial instincts or abolish distinctions based upon physical differences, and the attempts to do so can only result in accentuating the difficulties of the present situation. If the civil and political right of both races to be equal, one cannot be inferior to the other civilly or politically. If one race be inferior to the other socially, the Constitution of the United States cannot put them upon the same plane. Justice John Harlan in dissent. In respect of civil rights common to all citizens, the Constitution of the United States does not, I think, permit any public authority to know the race of those entitled to be protected in the enjoyment of such rights. I deny that any legislative body or judicial tribunal may have regard to the race of citizens when the civil rights of those citizens are involved. Indeed, such legislation as that herein question is inconsistent not only with the equality of rights which pertains to citizenship, national and state, but with the personal liberty enjoyed by everyone within the United States. The white race deems itself to be the dominant race in this country, and so it is in prestige, in achievements, in education, in wealth and power. So I doubt not it will continue to be for all time, if it remains true to its great heritage and holds fast to the principles of constitutional liberty. Our Constitution is colorblind, and neither knows nor tolerates classes among citizens. In respect to civil rights, all citizens are equal before the law. The destinies of the two races in this country are indissolubly linked together, and the interests of both require that the common government of all shall not permit the seeds of race hate to be planted under the sanction of law. What can more certainly arouse race hate? What more certainly create and perpetuate a feeling of distrust between these races than state enactments which in fact proceed on the ground that colored citizens are so inferior and degraded that they cannot be allowed to sit in public coaches occupied by white citizens? That, as all will admit, is the real reason of such legislation as was enacted in Louisiana. State enactments regulating the enjoyment of civil rights upon the basis of race and cunningly devised to defeat legitimate results of the war, under the pretense of recognizing equality of rights, can have no other result than to render permanent peace impossible and keep alive a conflict of races, the continuance of which must do harm to all concerned. We boast of the freedom enjoyed by our people above all other people, but it is difficult to reconcile that boast with a state of the law which practically puts the brand of servitude and degradation upon a large class of our fellow citizens, our equals before the law. The thin disguise of equal accommodations for passengers in railroad coaches will not mislead anyone, or atone for the wrong this day done. I am of the opinion that the state of Louisiana is inconsistent with the personal liberty of citizens, white and black, in that state, and hostile to both the spirit and letter of the Constitution of the United States. If laws of like character should be enacted in the several states of the Union, the effect would be in the highest degree mischievous. I am constrained to withhold my assent from the opinions and judgment of the majority.